Hey, what's up, everybody? Ralph here. So today's topic, I want to talk about what can debt collectors do if you don't decide to pay a debt that you owe. Now, for a lot of people, I know how intimidating it could be to have to get on the phone with a debt collector. Obviously, when you owe them money, you just don't want to deal with it. You know, you expect them to be very intense and pressure you into paying. But so for coming from someone who has experience with it, it's not as bad as you think. Especially when you understand the laws that are there to protect consumers. One law in particular is the Fdcpa, which is the Fair Debt Collections Practice Act. This protects consumers from debt collectors and how they can treat you like over the phone and how they can go about like collecting debt from you. So there's a lot of rules when it comes to like that FDCPA rule. So you're protected. Consumers are protected very strongly when it comes to this. So there's certain things that debt collectors can and can't do. So I'm gonna go over some of them. The first thing I want to go over, just make sure you understand, is like if a debt collector decides to call you over the phone, within 5 days after calling you, they have to send you a letter saying, notifying you that you do owe a debt in the amount that you owe and who's in the creditor's name. So this from the time they call you, within 5 days, they have to send you this notice. And usually by the time they call you, they've probably already sent it. So in a couple of days, you'll get this. And on that letter, typically it tells you, it shows you basically like it's a notification that, all right, this is an attempt to collect the debt, and within there it says within 30 you have a right to dispute this debt within 30 days of receiving that notice. So you want to make sure once you do receive this notification that it says all that. Right. So some of the things that they can and can't do, it's about I got like about 13 things in here on my notes. All right. So I'm gonna just go over some of the things they can do, they can do, and then there's a list of things that they can do. All right. So number one, all right, so they can contact you directly unless you tell the collector not to call you again or to contact your attorney instead, and you give the collector the attorney's contact information. If this is the case, the file usually goes straight to the collector. So they can't contact you, obviously, unless you tell them, going forward, that you want them to speak to your attorney. All right. So if you're okay with speaking with them, when I had debt, I never had them contact an attorney. I spoke with them directly. But if you have an attorney and you want them to speak with the attorney rather than you, let them know and give them the contact information. And from going forward, they have to contact your attorney. All right. All right, so next thing, they can contact you by phone between 8 a.m. and 9 p.m. unless you agree to other times. The collector may contact you outside those hours only if you give your permission to do so. So basically, they have a right to call you between 8 a.m. and 9 p.m. unless stated otherwise. If you want them to call you a certain time, let them know. All right, so they can't call you unless there's an agreement to call in another time. All right, so and also number 3, they can call you at work. All right. However, if you tell the collector that your employer doesn't like, debt collectors contacting you at work, then they have to stop. All right. So they would only be able to contact you by mail or whatever you agree on. So it's okay to contact your work unless stated otherwise. All right. Number 4, contact you by mail. However, the collector can't put information outside of the envelope that indicates a collection attempt or send information on a postcard. So obviously, and this is what I would recommend everyone. Like, most of your communication should be done through mail. All right. You want to make sure you have a paper trail, whether you negotiate how much you're going to sell it for, or just notifying that you have a debt, or you want to verify that the debt is actually yours. You want to make sure everything is in writing. This is what most people do when it comes to credit repair. Everything is done by through mail, unless you're negotiating a debt, and then you'll give them a call, right? But I would recommend most communication should be done through mail. All right. Number 5, contact others to get information about where you live and where you work. They can do that. The collector can request only contact information. The collector can't say that he or she is calling in regards to an owed debt. The sticky part, though, is like, say if a collector is calling say somebody you're at home, and then you say your spouse picks up the phone and your spouse says, "Who's this?" They can then identify who they are, but they can't contact others and ask you where you live and where you work. I mean, they can contact others to get information where you live and where you work. It's just that there's certain way they go about doing it. All right. They can supersize your statement, which only charges, so basically they can supersize your statement, only charges that you agree to under the original terms of the loan may be added to your bill. You can find the list of them in account terms in the fine print. These charges include endless fees, huge interest rates, hikes, and the cost of a collection, right? They also can ask for post-dated checks. Okay, so basically, depending on the state in which you live, the collector may be entitled to ask for post-dated checks. So you want to look into your state guidelines. Okay, another thing, they can tell the credit bureaus that you're behind on payment. All right, so basically, a delinquency that shows up on your credit report stays there for usually for like 7 years. So they can't tell the credit bureaus that you are behind on a payment. You usually see this in your credit report where it'll show you how many days, how many days past due, 30 days, 60 days, or 90 days. All right. They can also hike your interest rate. Right now, you may be hit with a penalty rate. You can't pay. You can't pay the current bill. So why would the credit increase your interest rate to 20-30%? This is something you might ask because you're at higher risk you're higher risk of a credit than they thought. So that's the reason why they would hike your interest rate. All right. So another thing they can do is repossess your purchase. Obviously, if you have a car that you're behind on, obviously they can repossess that. So a lot of people understand how that goes. If you're late on payments and you're not paying, you're not responding, then obviously they can come to your house or wherever the car is and repossess it. They can sue you in court. I know this firsthand how this goes. So this is very important because if you get a letter, like let's say like for instance, like I stopped paying like credit card debt and then I just stopped paying. Then they sent me a letter saying, all right, they're going to sue you in court. And then at one point I didn't respond. That's the wrong thing to do. If you ever get a judgment, a letter in the mail saying they're going to sue you and they want you to respond by a certain date, make sure you respond. Or if they ask you to come to court, go to court, because if you don't show up, then obviously that means that the judge is going to say that you are guilty, and then that gives the creditor the access to your bank accounts. So if you get a letter saying they're suing you and that they want you to come up in court, make sure you respond, and if you have to go to court, show up. I think a couple months ago I had an issue where I had this old debt, about $5,000. And the creditor, the original creditors, they wrote it off, they charged it off. So, obviously I owe them money, but they wrote it off. So I didn't really owe the money to them anymore because they wrote it off and they weren't coming after. But a couple of years after that, I got a letter from a creditor saying that, all right, you owe this debt. What I did was, obviously, I had a verification letter and asked them to verify that I owe this debt to them. They then sent me a letter with some old bank statements, like, all right, they had a balance, but that's usually not enough. So I just ignored it. And then I think a year later, I got a mail in a letter saying, all right, you're being sued, and you have to go to court at a certain date. What I did, I was like, all right, you know what? I'm going to go to court, because I remember last time that happened, I didn't go to court, and then I lost the case, and they really tried to, garnish my bank account. But I made sure to show up. I was like, yo, I'm going to make the judge have to make me owe them, give them the money. So I went to the court. I showed up. It was over Zoom. I stated my case. And then basically what they said was, I've told them that, there's no written contract between me and that creditor. I won't name the creditor's name, but there's no contract between me and this creditor, this third-party creditor. And then the judge was like, all right, so what we can do is like we'll re-adjourn in 6 weeks, and I'll allow the creditor to come up with, if they can come up with a full accounting of all the payments, interest rate. They had to come up with a full accounting of all the charges that I made, and then 6 weeks we'd come back in and discuss it. 6 weeks came. I got no letter in the mail saying that I have to return to court. So I'm thinking they dropped it. I haven't received anything so far, so I think I'm good, because obviously they know they weren't going to win that case, and I was going to make them work hard to win that case. All right, so if you ever get a letter trying to say they sue you, make sure you show up, because they can't sue you. Doesn't mean they're going to win. I did all my research when I made sure when I went to court. I was like, all right, I don't have any contract with them. There's no legal binding contract that states that I owe them the money. So far so good. I haven't received anything, so I think I did a good job with that. All right, next thing, they can change the terms of your agreement. All right, so let's say you stop making payments, they can then change the terms of the agreement and raise your interest rates. Some collectors may allow you to make up whatever you owe over time by adding the amount to future payments. Some, to their credit, offer hardship programs, but usually only if you ask. Be sure to get any changes on your agreement in writing, particularly if communication starts strained at best. You need documentation to ensure that your agreement is honored. All right, and the final thing that they can do to you is accept or offer a debt settlement option for less than the full amount owed. This is what I've done when I owed, you know, $30,000 of credit card debt twice. I stopped making payments on it, and then when I had the money, I would then call them back and say, all right, let's negotiate, you know, a payment. I didn't make payments. I just made a one-time payment, because you never want to make you never want to create a, how you say, you never want to negotiate payment installments, because then that'll make sure that'll mess up your credit. It'll drop your credit. It's a long story why it happens, but it'll restart your bad, you know, payment history. So you just want to make sure you knock it out in one shot. You just negotiate a one-time payment and say, this is what I have, one-time payment, and then boom. And make sure you get what's that letter called where a pay per delete, if you can. Some do it, some don't. But once you negotiate, say like if you can give me a pay per delete, we can negotiate this price. Some would do it, some don't. At the time, I didn't know about that, so I just negotiated one-time settlement, and then it basically on my credit report, it was basically notified. It was worded as paid in full, paid for less than the original amount. Which is not good, but you know, at the time I didn't know. But yes, they can call you and they can offer and accept a debt settlement, which is, you know, if you owe debt, is a good thing to have. I mean, it's a good thing to negotiate. All right, so now going to the things what they can do. I mean, what they can't do. All right, so those are all the things that they can do. What they can't do is threaten you. All right, now based on that, like the Fdcpa act that I told you about, they can't threaten you over the phone or through mail. All right, so in writing or in mail, the collectors can't use like any foul languages or threaten abusive or obscene language, and it's not allowed. They can't do that. So that's why when I talk about when you call them on the phone, it's not as bad as you think, because there's certain things that they can't do. They can't threaten you over the phone saying they're going to do all types of crazy things to you. All right, and they can't be annoying. All right, even though, I mean, obviously that's, you know, I mean, there's a fine line between being annoying and asking, you know, there's a fine line between annoying and what they're trying to do. But yeah, they can't be annoying. They can't be deceptive. They can't trick you into like making a payment. All right, they gotta be straightforward. All right, this is what we negotiate or whatever. This is what it is. All right, and they can't lie about the consequences. They can't say, oh, we're gonna claim that you've committed a crime or anything like that. They can't do that, and they can't make idle threats. Okay, so these are certain things that they can't do. So it helps to understand, like if you're someone that owes debt, it helps to understand what, you know, creditors can and can't do. Like even for myself, learning these things, like it made it much more comfortable and gave me a lot more confidence when it came to contacting them. I remember the first time I contacted a debt collector about negotiating a debt. I called them. I was like, all right, you know, this is what I have. This is what what you want to do. He gave me a hard time, and I was like, you know what? All right, I could feel like it was getting heated. So you're like, you know what I'll do? I'll just call back tomorrow. I called the next day, you know, hopefully I got, I was talking to somebody else. And I said, all right, boom, this is what I got. It's come to an agreement. And then they took that amount. And I was, you know, I made sure to get it in writing. They sent me through an email, through an encrypted email. I agreed to it. I signed a contract. And then once they did that, I made sure to send payment, not through a check. I didn't let them get access to my bank account. I think I sent it like certified mail or something like that, a certified check. Not certified check, like some other type of check that doesn't get access to your bank account, because you don't want to do that, because if you give them access to your bank account, they might take more than the amount. Although it is agreed, but you want to make sure you don't ever give them access to a bank account. All right, so yeah, so these are the things that you can and can't do. Hopefully this was helpful. It helps to have this type of knowledge, especially when if a lot of people that have debt and you're thinking about negotiating with them. So it helps to understand that understand how to go about, dealing with, trying to, clear up debt on your credit report. So I hope you find this helpful. If you got any questions, comments, leave a comment down below. Hit the like button, share, and subscribe. Right? So I'll catch you guys on the next one. Later.